Have you ever found yourself needing an official document for an important process, only to realize the original is lost, was never issued, or is simply impossible to get? It can feel like a major roadblock, especially when dealing with something as crucial as immigration. But what happens if you cannot provide your original birth certificate for a USCIS application? USCIS, which stands for United States Citizenship and Immigration Services, absolutely accepts secondary evidence of birth, but only when a primary birth certificate is truly unavailable. The core purpose of this evidence is to establish fundamental facts about your birth, such as your date and place of birth, and who your parents are, which is vital for proving your identity and eligibility for various immigration benefits. The reason USCIS requires this proof is to ensure the integrity of the immigration process, confirming family relationships and personal details. Secondary evidence becomes necessary when your birth was not officially registered, records were destroyed due to natural disasters or conflict, or the government agency responsible simply does not issue such documents. In these situations, USCIS expects you to first attempt to obtain a letter from the appropriate civil authority stating that your birth record does not exist or is unavailable. This explains why you cannot provide the primary document, paving the way for your secondary submissions. So, what kind of documents can you use as secondary evidence? Acceptable forms often include baptismal certificates, school records that note your date and place of birth and parentage, census records, or medical records from your birth. If multiple documents are consistent, that strengthens your case. When official records are still insufficient, USCIS may consider affidavits, which are sworn statements from individuals who have personal knowledge of your birth, such as a parent, older sibling, or midwife. These affidavits must include their full name, address, relationship to you, and explain how they know the facts of your birth, along with their signature and the date. When compiling your secondary evidence, a key detail to remember is consistency. All documents should ideally reflect the same date and place of birth and parent names. If there are any discrepancies, you should be prepared to explain them. Furthermore, any documents not in English must be accompanied by a certified English translation, confirming that the translator is competent and that the translation is accurate. Always provide certified copies of your documents, not originals, unless specifically requested. These steps demonstrate your diligence and help USCIS process your case more efficiently. Ultimately, successfully navigating the USCIS requirement for birth evidence, even without a primary certificate, comes down to thoroughness and presenting a clear, consistent picture of your birth facts. By understanding the reasons behind these requirements and carefully gathering the best available secondary evidence, along with a statement explaining why the primary record is unavailable, you can confidently move forward with your immigration application, minimizing potential delays and ensuring a smoother journey.